on the split oak, so I'll just start off with saying that 86% of the voters said for us to protect split oak in its current form. Statistically, I will say that there's no elected official that will probably ever get 86% of a vote to get elected. Statistically, I mean, I don't know if it's ever happened, but like I have never seen it happen, but you know, that's a lot, 86%. So back in December of 2019, the Board of County Commissioners approved the resolution. And I would like to ask, and I have several questions, and we are short on time, so Attorney Jeff Newton, I'm going to ask you some questions. Keep your answers short because of time, please. So that resolution in 2019, what did that mean? I know in our briefing you said that it just meant that the board supports. Well, I'll just let you say it because I don't want to put words in your mouth.
Yeah, it was a resolution of support for the Osceola County Expressway extension.
Okay. And then in August of 2020, Osceola County files a complaint against the county or against the CRC because of a charter amendment. Then the charter amendment passed in November 2020 with, like I said, 86% of the vote. And then, you know, the Osceola County files another complaint. Was that toward, I believe.
The initial complaint filed by Osceola County attempted to enjoin the county from even having an election with respect to the ballot question on Split Oak Forest. Subsequent, the process was what we call a Chapter 164 process. And let me back up and say, before you file litigation, as a governmental entity going against another governmental entity, you're supposed to go through basically a mediation process. Well, it was determined after having met with Osceola County, as well as I believe there were two other interested parties involved, that the mediation was not going to change anything because the county was not going to change its position and Osceola County was not going to change its position as well. And so Osceola County decided to move forward and file suit against the county and had basically an allegation that the charter provision that had been approved by the voters effectively modified the various agreements that Osceola County and Orange County had entered into with FWC and the Florida Communities Trust. And so that litigation has been ongoing. In that litigation, contrary to what you heard at public comment this morning, Orange County is defending the charter amendment along with, and our interests, Orange County's interests are aligned with two interveners, namely Chuck O'Neill on behalf of, Chuck O'Neill is there individually on behalf of Speak Up Wekiva, and then there's another group that's also involved as an intervener in the litigation. And so our interests are aligned with those two organizations in defending the charter amendment. I think what gets confused by the public is that separate and apart from that litigation where the county attorney's office is defending the litigation to uphold the validity of the charter amendment is the determination that this board made based upon its passage of that resolution to support the Osceola County Extension Project. And so I think there's confusion there. I think there's misinformation there. But regardless of that, at some point in time, the Board of County Commissioners will have to make a determination, and I think it's been set forth before, the board will have to make a determination whether or not those prohibitions, those restrictions that are contained within the Split Oak Forest Charter Amendment are applicable to whatever it is that FCT decides, or Florida Wildlife Commission decides, needs to be done to implement the construction of the linear facility, namely the Osceola County Expressway extension.
Okay. So between November 20th and April 20, 2022, sorry, it's a mouthful to try to say that date. What has been done by the county? Like I don't remember, and I'm going through the historic and current actions memo that we got. So between the vote, let me see, following written argument, parties, there was just actions by the attorney's office on what you were just mentioning. But then April 20, 2022, the FCT governing board considered the request. But between the vote by the voters and FCT meeting, that was, let me see, 1 year and 2021? No, about a year and a half, I would say, that had passed. And from what I'm seeing, the board did not meet to discuss the charter amendment. But during that time, the county staff, not the attorney's office, county staff, was providing information to FCT that they asked for, requested, based on the application for, because the counties applied to FCT for the linear facilities in May of 2020 before the vote. So the county staff continued their actions based on that resolution, regardless of the vote that happened in November 3rd, 2020, and without coming back to the board to see if the board had any, the board wanted to do anything, after the vote. So the board didn't have the opportunity to do anything because the board didn't meet on this issue. I mean, am I missing any meetings that we possibly had between that time?
No meetings. County staff acted consistent with action by the Board of County Commissioners in December of 2019.
Okay.
Everything from that point indeed were the actions that we said we would do, which was to provide information, participate in meetings, and so forth. And what we said in those two memos was that when there was a decision forthcoming to the board, then the board would indeed have to determine if they wanted to accept the donation of land, for example, agree to the management of donated lands, address conservation easements.
Okay, I'll get
as
there.
well.
I'll get there in a second. I'm just
No,
clarifying, but
gonna
there was
say-
no meetings by the board to make any alternative decisions or to give any alternative direction to staff. All right, so then FCT met in April 20, 2022, and then on May, so that's like maybe a week later, we got a memo from APD summarizing those actions. And then a couple of days later, Central Florida, they passed their own resolution. And then June 7th, that was with the lawsuit again. And this memo then that I'm reading right now, reading this off of, came in July. So then we got another memo in July summarizing everything. But in this memo in July 2022, again, we still haven't had any meetings by the board. It lists some possible future board considerations, which you started listing off, Byron. Consideration of a resolution, consideration of conservation easement, amending future land use, determining need for restoration, revision of FCT, grant award agreement revision, a whole bullet list of stuff. But all these bullet list items that was for possible future board considerations was in alignment with that 2019 resolution to support it. Is that correct?
Yes.
Okay, so there wasn't no staff guidance to the board that another possible future board consideration could be not to move forward based on the 86% vote by the voters. That wasn't a consideration,
That's not a staff determination.
but you are making recommendations of some actions.
Consistent with the
Possible.
board direction, December of 2019.
Yeah, and then on page 2 of this memo too, it says, a work session updating the board on the OPE project and SOFWEA and status of these FCT considerations. I think there's a grammar error here. It says in, but I think it's supposed to be is, planned for early 2023. We're at the end of 2023. And I know at least a couple of board members, including myself, had requested a work session. And I was told it was coming. Did we ever have, because I'm just, so much happens and I can't remember everything. Did we ever have this work session in early 2023?
So the work session was predicated on when there would be some action, something different, decisions that would come before the board. This process moved much slower. As you recall, Commissioner, from many conversations, this process at the state moved much slower than we initially anticipated. We thought that it would be moving quicker, and it didn't. It is where it is now, which is the same notice that you received, we received. We weren't notified in advance. We had to find out ourselves from our EPD staff about FWC, which is the first opportunity, and we don't even know what will happen at that meeting on the 5th, but that is the basis of when there would be some action before the board once we know what direction this is going from the state. That was the basis of those past conversations and the communication.
Okay, but this says here, a work session updating the board on the OPE project and the Split Oak Forest and the status of these FCT considerations is planned for early 2023. This is these FCT right here, considerations. So this memo, so basically what I'm seeing here is that we were supposed to have a work session early 2023 based on the information in this memo.
Based upon something coming for the board for action, for something new, something different. That was the predicate.
No, it says just updating.
That was the predicate of those discussions, Commissioner.
Yeah, but the work session was supposed to be only updating us, which we didn't get. And I know a couple of, like I said, of us asked for a work session, didn't happen. And now we're here, there is action coming. But the thing is, so you as staff, you're just following the direction of the board. And the board had provided a resolution for you to support that road, and you all have continued in that direction. However, the voters, something significant changed. 86% of the voters voted for us not to move forward with that. And yet this board did not have the opportunity to discuss that and discuss alternative actions.
Commissioner, as you know, based upon your commissioner's report today, at any point in time, a commissioner, mayor, can ask for a discussion on a particular issue. So the question is,
Thank you so much, because
So the
yes, but I was told that it was
question is-
coming, and so I just waited, trusting that it was coming. But now we have this December 5th meeting happening,
Yeah,
which
and-
I would have loved to have a discussion before any action by the state
and
took
no one
place.
knows what's going to happen at
No
that
one knows
December
what's going to
5th
happen,
that
except for the
December 5th
thing
meeting.
is, our staff continues to go forward
Because that was the-
supporting the resolution.
That was the direction they received.
Yes, I understand that. I completely understand that. Staff is following the direction of the board that was made in 2019 before the vote of the voters. What I'm saying is there was a significant action that took place by the voters, 86%, and this board did not have the opportunity, although it's my fault. You want me to take the blame? I'll take the blame. I should have done a commissioner's report months ago, maybe years ago. I'll state that. But I didn't think there was any urgency to do that, just like you're saying, there was nothing that you had, nothing happened, according to your interpretation, nothing happened, right, that needed the board to discuss it. Okay? I'm not in disagreement with you. Okay? What I am asking, though, is that after that significant action, we asked for a work session to discuss that action. We were told it was going to happen. It hadn't happened yet. Maybe it was going to come early next year instead of early 2023. But you know what? As a legislator elected by the people, I'm here doing my job, and I'm asking for this work session so that we could discuss this. I'm not disagreeing with anything that you're saying. Now I'm going to ask you, though, is there anything stopping this board from doing a new resolution based on this vote to say that we do not no longer support this because the charter says we can't do it, or we shouldn't do it? We can't do it.
Well, I think your rules of procedure, because that resolution would effectively be rescinding what it is that you've done in the past, don't permit such. But if you want to suspend your rules of procedure and go forward and try to undo what has already been done, that's certainly up to the board to try and do that.
Well, that's a new
How do you
resolution.
get there, though, Jeff? If
5 votes, suspend your rules.
Okay, all right. Think you understand what he's saying?
I understand what he's saying, but
Commissioner Wilson is chomping at the bit to ask a question, but
I don't
Commissioner
believe we need to
Bonilla has
rescind, though.
she has the floor, and she's, so.
Yeah, and I don't believe we need to rescind that. We're doing a new resolution based on new information.
Well, if you're not rescinding the prior vote, if you're doing a new resolution based upon new information that's come forward, you're more than welcome to put that resolution out there and see what happens.
Yeah, so that's not rescinding. That's just doing a new resolution.
That's correct. That wouldn't be rescinding if it's based upon information that was not known at the time that the original resolution was taken.
Thank you. My point, so we had a vote of 86% of the voters that we did not have before. That's a new action, new information, and there's nothing stopping us from doing a new resolution based on that information.
You could try it, yes.
Okay. And what you mean by I could try is that I need a majority to vote to agree with that.
You need 4 votes with respect to that resolution.
Okay. Thank you.
Is it 4 votes?
4 votes. Majority
votes.
of
It
the
was
board.
5 votes in order
Majority,
it was
right?
5 votes related to the linear facility. It was 5 votes. It's only 4 votes.
Right.
But there is a provision in the Florida,
It's land swap.
excuse me?
I think you're mixing up the land swap
Yeah,
provision.
I said there was 5 votes with respect to the linear facility.
No, linear facility didn't require the higher threshold.
It was 6 votes with respect to the other provision.
Right, you
Right,
went, the 2019 board
Right.
went with the lower threshold.
right, correct. And that was, I think it was maybe it was 5-2 in terms of the vote, and that it was only a majority that was needed.
Okay.
So my question to the
5-2,
board
right.
members is, do we want to adhere to what the voters voted for and what our charter now is, or do we want to go against 86% of the voters and what the charter is? I mean, I made an oath to uphold our charter. All right, I will open up to, I'll
All right, so,
step down from my
okay.
time.
If you're finished with your presentation or your line of question, then I'll go to the other members of the board, and I'll call on them in the order in which they have pressed the button. Commissioner Wilson, and then Commissioner Scott.
Thank you, and thank you for bringing this forward. I do want to just kind of go back and revisit the timeline, because I need to understand a little better. When we got notice that Florida Communities Trust was holding their meeting, and they were evaluating an application for a modification for an agreement. That application for modification was made on behalf of Orange County and Osceola County and their investment in that agreement for Split Oak Forest. At that time, understanding that once Florida Communities Trust evaluated this, we would be in a much worse position, I did send a memo and asked if we could revisit this. I was told at the time that I was the only board member, because I was the only one at the time that wasn't here in 2019, that could not request that it come back here. Fast forward to the Florida Communities Trust meeting, I was the only member actually speaking on behalf of what the charter amendment said in those, requests for protection. And there was a very clear presence by Orange County staff and legal department and our environmental department alongside of Osceola and the Central Florida Expressway in support of the 2019 resolution. So when you said that the county isn't going to change its position in defending the charter, where is that happening? Because if it didn't happen in the occasion where we needed it to, I'm not sure where it's going to be effective.
Understand, we're defending the charter in terms of the allegations that have been made that the charter provision is simply invalid. What you also need to understand is that charter provision contains an exception, and quite frankly, it's an exception that's wide enough to drive a Mack truck through. It's an exception that was placed there by the attorney for the Charter Review Commission, which essentially places the decision back in the board's lap to determine whether or not what is occurring, what agreement may be entered into, and whether or not the agreements entered into or the I think there were two things that Mr. Brooks mentioned, whether those agreements that still need to be revised, modified, et cetera, have the effect of enhancing this. Let me read it specifically from the charter. It says whether or not that would have the effect of, let's see, greater, additional, and/or more stringent protections for the wildlife, vegetation, environment, or the preservation of the use of split oak forest as conservation land. So that's the exception that exists in the charter. And so the staff had direction in terms of supporting the Osceola County Extension Project. And so that's what staff was doing when
In 2022.
In 2022. It still had that direction. The direction had not changed. Even though there was a vote that took place in 2020, that direction had not changed. Now, I'm trying to recall, I think there was an attempt at some point in time to change that direction subsequent to the charter amendment. I'll have to go back.
No, there wasn't, not since
look.
I've been here, because I asked for it to come back up.
It happened prior to Commissioner Wilson coming. My recollection is that
It
there
did.
was an attempt before the board, but didn't
go.
prevail.
Okay, so my recollection is not correct on that point. But they're really two separate things. What the charter provides and the exception in the decision that this board will ultimately have to make with respect to whether or not that exception is applicable versus the county attorney's office defending the charter provision that was passed by the voters.
Okay, and I understand that those are two separate things. I think my concern in being as transparent and sincere with the public as possible is the full-throated statement that the county isn't going to change its position in defense of the charter. When we talk about the county, you're speaking about the attorney for the CRC. That was not the county attorney's office here.
Exactly.
The county attorney's office here has not only not brought this back or given us any assessment, I think, of FCT's evaluation prior to or post FCT hearing, all the way, now we're at the very last layer, right? These protections, environmental protections like this come with layers. We are now to the very last layer, and what we're still hearing is that at any time, any one of us could talk about this and bring it back to the board, except me, who's the only one that's asked for that. And so what I feel like is that every moment.
Is that accurate? What Commissioner Wilson
That was part of the memo back in December of 2019,
Yeah.
because she was not a member of the board at the time that the action was taken by the board. And so she could not move to rescind the action. That's
Okay.
what it was the last time around.
Right.
But that's rescinding.
That's rescinding, right.
But if there was
But I
New
think-
information.
But even then, right, the
to
conversation.
advance this with new information, she could do that.
Yeah, I just responded to Commissioner Bonilla that
Well,
basically said that.
At that time, the response, and I can reprint these for you all, but the response was that you all would come forward with the information if it was relevant to us and pertinent to this topic. And that has yet to happen. And understanding that we're now at the last layer, right? We are at the very last layer. And having the opportunity to allow this board to absorb and understand better, what I feel like was a lot of information brought to you all in 2019 by the Central Florida Expressway Authority about the protections that were largely inaccurate. A linear facility is not a toll road. A linear facility is a power line. If you look at the use of those types of linear facilities across the state, and the allowance for them to come in and take apart this conservation land is what I feel like has been very manipulative to this board. And in 2019, I understand we didn't have as much information. There is now all the information. Florida Communities Trust sadly said, we believe in home rule. Strange, right, to hear it out of Tallahassee. And I thought, oh, excellent. Then this is where we're going to be able to stand up here and tell everybody, well, if you believe in home rule, let me tell you what the people in Orange County believe about that forest, that it needs to stay intact. And that severing 160 acres off of it is not a linear facility and it's not keeping it intact. And the Florida Constitution is super clear about the only way that those conservation determinations should be able to be removed is if there is a determination that there's no longer conservation value. And that was never done. That was never done. This was presented as a land swap to you all. This was presented as something that, you know, was really advocated for and by a private developer. And I feel like you have the ability now to see it all in front of you and for us to maybe take action to prevent this from going any further with our endorsement. I'm not saying we can stop it at this point, but our endorsement is what's on it right now. And that's not okay.
Okay, Commissioner Wilson? You're done. All right, Commissioner Scott.
Thank you, Mayor. Attorney Newton, so for a process part, you're saying the first thing that would have to happen is we would have to vote, a majority vote, not for, but supermajority vote to suspend our rules of procedures, right? Or no?
No.
Okay, so moving on to the resolution, it would be a vote of 4 or 5?
4.
Okay, and then you said that.
For a new resolution.
For a new resolution, can you provide just a little bit of context on why you initially said we should have to rescind the previous one as opposed to adopting a new one?
Well, that was the issue that came before the board back in December of 2019 was whether or not Commissioner Wilson could rescind the board's prior action. And so that's all that was discussed was rescission. There was nothing at that point in time. There was no charter amendment that had been passed by the board. So there was no discussion about doing a new resolution which would effectively no longer indicate this board's support for the Osceola County Expressway extension.
So then now with the new information, that memo doesn't apply to Commissioner Wilson anymore or myself, we could make a motion.
No, we can't.
Not rescinding. You're not rescinding the
So we
board's
can't
previous
rescind,
action.
but
You're
we
doing
can-
a new resolution altogether.
Okay, and then the other question, and I don't know if this would be you or Mayor, what changes, what information could we request given the fact that we have 2 members of this board who also sits on the Expressway Authority?
Repeat your question again.
So both the mayor and Commissioner Moore sit on the Expressway Authority. We have new information. According to Commissioner Wilson, you guys were supposed to, the county attorney's office was supposed to bring some additional information.
Well, not the county attorney's office, no.
Who was, that's the place that I'm not clear on.
Yeah. We have kept the board, I think, somewhat apprised of the litigation that has been involved with Osceola County.
Okay, I'm good now. Okay, I got confused in that piece right there, so thank you. No other questions.
And I did say at the end of my memo that I think that memo in December of 2019, I said something about bringing information
that you
forward
would
when
bring-
things changed.
Yeah.
But that was with respect to the litigation.
Copy that.
And not much has changed there.
No, I'm
Yeah.
sorry, but it actually says that the board will be updated as of FCT's decision at that time.
Okay. And
So
so
we've
yes,
had nothing.
and so we haven't had any decision by
Yes,
FCT.
FCT did make a decision.
Okay. And so-
Based on, in part, Orange County's support
Okay.
of this alignment. Right? Orange County's support
So
of this
that-
alignment was part of the FCT's decision.
So
Which is
that
what I mean by
decision-
that cart.
Was that decision provided to the board once
No.
FCT had made that decision?
No.
There was no memo or anything that came out related to that? I don't know. Staff is not.
That's a question for the county
yeah.
administrator.
Yeah, and
In terms of as we kind of evolved since 2019. There have been memorandum forwarded to the Board of County Commission with status updates. Is that what you're saying?
David Jones
Byron?
was the last one that I got.
Yes, Mayor, we've provided, and the last one was the June, I don't have it in front, June of 2022. Now, in terms of, again, lining up what those actions were, what are the actions that the Board of County Commissioners may ultimately take? That was the predicate of that, of saying we bring back when there's some action for this board before you. The update, FCC, that was not an action for the board to take.
But
At least that's not what we view
the
it as.
information was
action for
provided
the
to
board.
members of the board
Well-
is the
May,
question.
yeah,
I'm
May
asking.
2nd, 2022
Okay.
is when
So,
the information.
yes, there was information provided to the board.
Mayor, and I apologize, but at the time we have, and I can make sure we have copies of this in front of us, okay? Because I do feel like it's getting a little foggy. And what we got was actually a memo or a letter from EPD, which, with all due respect, this was a question about a legal determination, and EPD, they're there to evaluate, I think, the biological pieces of this. And the EPD memo, to much surprise to me, basically said this is on Osceola County, this is not us. And here's the problem with that, is that that's an interpretation of our agreement with Osceola County. And it's a false one when you go based on the actual language in the agreement, which is that every member of the agreement has to agree
Okay.
to any modification.
So here we are today, so we can, Commissioner Bonilla asked for a commissioner's report. What is the direction that the board wants to give to county administration at this point? Or what additional action would you like to see come from this conversation? Commissioner Bonilla. Commissioner Bonilla.
Yeah, so, I mean, the state FWC is meeting on December 5th. So I feel that this board should direct staff to state that we no longer support this toll road through Split Oak Forest because of the vote. 86% of the voters voted not to do that.
That we continue
Okay.
to support the
So,
agreement.
I mean, we can't have staff continuing to go over there and tell them that we support this, because that's what they were directed to do in
Okay.
2019 before the vote.
So Commissioner Bonilla has articulated what she would like to see done.
And I would like to see a new resolution, too.
What's the process in terms of exploring whether or not the board is in agreement with what she said? This item was a commissioner's report, not on the agenda today for an action item or any of that. Is there a requirement to move forward with having that conversation where there's an opportunity for public input, other presentation, legal research, anything else that needs to be done so that the board can make an informed decision when asked to vote on said resolution?
Well, I think there's at least one commissioner that probably is not up to speed on everything related to Split Oak, and so I think that Commissioner Scott may need some additional information before voting on what might be a resolution or just a motion made by the board.
So, point of order, or
So
is that question?
I'm still kind of here.
Question.
In terms of what you just said, Jeff, there's still a process that has to occur. What would that process look like? Okay.
Well, I mean, it could be the drafting of a resolution if the board gave us direction to draft a resolution, which effectively would be a resolution saying that we no longer support the linear facility that's been voted on by FCT.
Okay, and that you could not craft today?
No.
Okay. So to me, what that says is that we'd have to bring that back on some other date.
If it's going to be in the form of resolution, yes. If it was going to be just a vote today as a non-agended item, it will require 5 votes.
Okay, so there's two things that he just said. So if we took a vote today, because it's a non-agenda item, it would require 5 votes.
Correct.
Okay, and if we brought it back to allow time to craft a properly worded resolution, we would have to bring that back on another date.
Correct.
Okay, so there's 2 courses of action.
Well, let me correct one of those, though. This is an agenda item, and based on history of commissioners' reports, there has been votes on things that have been on commissioners' reports. I remember one of them that was done by, she's like the county clerk now. I can't remember her name.
Tiffany
Russell, yeah, Tiffany Moore Russell. And that was on changing the whole land use structure, that commissioner's report and that vote. So it's only a 4 vote for a commissioner's report.
I disagree with that. There's no request in this commissioner's report item for there to be a vote.
Okay, so that's the distinction between perhaps what former county commissioner Tiffany Moore Russell brought forward. What the county attorney is saying, opining here, is that inclusive of her commissioner's report was to take a vote.
No, I'm not saying that. I don't know whether that was the case or not. I'm just saying that with
Okay.
respect to this report that's been brought by the commissioner, there's no indication that there was going to be a vote on an issue.
And therefore, you're saying that because in this instance, there was no indication, we agendaed the item, there was no indication for a vote. Today, it will require 5 members of this board
Correct.
to vote to advance it further. Okay.
Can I clarify that? Because
What I mean by that is the
The only thing that was agenda was to have a discussion about the upcoming December 5th meeting of the FCT.
What I'm saying here, Commissioner Uribe, you may have been out for part of the discussion, but Commissioner Bonilla, I believe, is kind of indicating that if today, if 5 members of this board voted to advance something similar to a resolution that would say that this board no longer supports the application for the linear facility that's pending before the Florida Communities Trust, Florida Wildlife Commission, that she would advance that today as a possibility, or if it isn't done today, in order to give commissioners the opportunity to be informed, that will have to come back on another date, and it would take 4 votes on that date. Okay, is that clearer for you? Okay, all right. So, okay,
That's correct, Mayor.
okay, all right. Okay, Commissioner Bonilla, we'll go back to you now.
All right, so, I mean, we've had discussions before that we've made votes on that didn't say we're going to have a vote, so, I mean, we could disagree on that. But anyways, I would hope that the majority of this board supports the voters, 86%, that they voted on against this. So I'm going to go ahead and make a motion. I mean, there's 2 motions I would like to make, but
Okay.
I'll just start with one motion at this time.
Commissioner, just for procedure purposes, I want to get clarity from the county attorney before you make your motion.
He says we need 5.
Okay, there are a few questions. I mean.
Oh, okay. I thought everyone, okay, go ahead.
Okay. Commissioner Wilson, I don't know if you've already spoken.
It was just, I mean, actually, it was just a follow-up to understanding that, so obviously, as somebody who really wants to see that we align ourselves with what our voters align themselves with and that we do the right thing here, the idea of that lower threshold is very appealing. But we're also working on a timeline, right? Because FWC is meeting on December 5th. So I guess my question is, can we at least, gather a consensus
That's
to
what I was
say
getting
that
ready-
staff direction
That's what
shouldn't
I'm-
be to go support and
That's
align?
what I was getting ready to
Okay,
say,
perfect.
Commissioner. If you want to not take a formal vote, but if you want to gather some consensus that's certainly an option.
I was going to note, though, staff was not, I saw Beth for a second, staff was not intending to speak at the meeting, the upcoming meeting. We were not intending to participate in terms of speaking at that meeting.
I think it still needs to be more formal than that. Thank you.
Okay, Commissioner Wilson, that's your comment. Let me go to Commissioner Scott.
I just would like, and maybe you can't provide it here today, maybe later on, but my understanding, and the rules of procedure are pretty clear, you have examples, but the rules of procedure stipulate that non-agenda items require a vote of 5, and agenda items require a vote of 4. However, we received an amendment, and it doesn't, from what I've read, again, I could be wrong, I'm not an attorney, it doesn't specifically stipulate how it listed. It just specifically states, hey, it must be on the agenda. While it doesn't reference a vote, it is an item on the agenda, and based on my understanding, again, I'm not an attorney, on my understanding, based on the orientation I had with your department and what I read, it's an agenda item, it will require 4. It doesn't say it has to have, it just says agenda items require a vote of 4, non-agenda items require a vote of 5. Given that the Agenda Development Office sent us an amendment prior to the start of this meeting, it is an agenda item. And so for me, I'm just trying to understand clarity about process, because that is a little confusing to me.
Well, the part that's not agended is the fact that there's going to be a vote.
But it doesn't. But it doesn't stipulate that. That's what I'm saying. It doesn't. It just says agenda item. It doesn't say about a vote.
There's no action requested or anything there's no action requested or anything with respect to the item. And so from that standpoint, the public has no knowledge whatsoever on there being a vote on this particular issue at all. None.
Okay, so given that context, I agree with you. At some point, I think we want to look at our procedures to maybe, because that is a little confusing to me.
Clarify
as an
it,
individual. Because it doesn't, it just says agenda, non-agenda. And so that is a good point. Thank you. Thank you, Mayor.
Okay, all right. Those were the questions. All right. Now, Commissioner Bonilla, you're welcome. If you've heard the dialogue.
Yeah.
There's, it was an agenda for a vote. So if you want to advance something, the third option is if there's some consensus without taking a vote, we could consider exploring whether there's a consensus of the board. To me, that's akin to taking a vote. Okay, so I think that if that is the case, it just seems to me that the proper thing to do today is, if there's a motion to go to the FCT, the FWC on December the 5th with some direction by the board, the Orange County Board of County Commission, that it should be a vote. And if it happens today, it's going to require 5 persons to vote in favor to do that. Okay. All right, so are you prepared?
Yeah,
make
and
a
I
motion?
I will just say, everything that's agended is assumed that there could be a vote, because it's agended. I'll just go there. So, yeah, and I'd have to go back to Robert's rules and see what they say to really get to a good response on
At
that.
this point, the county attorney is the one that has given the advice, so, yeah.
Yeah.
He's the attorney for the board. All right.
Okay, so, I would like to get a feeling for the board first. Because the thing is that I really don't want, staff says that they're not going to speak, but what we really need is for staff to go and say, we had a vote of 86% of the voters, and, the board no longer supports, this moving forward.
Well, the 86% is one thing. To say that the board no longer supports moving forward, that's a different thing. That's a change in direction of the previous vote that was taken by the Board of County Commissioners. So
Okay,
if-
you know, I'd prefer everyone to be on the record, so I'm going to go ahead and make a motion. I make a motion that we direct staff to let FWC know that we are no longer supportive of the road going through Split Oak Forest, and to give direction to staff also to go ahead and write up a new resolution.
So it seems that the proper motion would be that,
There should be rescinding.
the board no longer supports.
We're not
No, it
rescinding.
wouldn't be rescinding because of,
New information.
New information.
it's, right, say that again?
Vote of the
New
voters.
information. Because of new information,
Our charter changed.
the Board of County Commission no longer supports the pending application. Would that be appropriate? Okay. Before the FCT or the FWC?
Second, Wilson.
Correct.
Okay. That would be the proper motion.
Okay, I'll amend my motion to what you stated.
Okay.
Second, Wilson.
All right. So we have a motion and a
I
second.
know. Mayor, can you repeat that for me,
The
please?
proper motion would be that the Orange County Board of County Commission, given new information that has been provided relative to the charter amendment vote of 2020, was it?
2020.
It no longer supports the pending application before the FWC and the Florida Communities Trust.
Second, Wilson.
Okay, all right,
Y'all got that?
okay. We have a motion and a second,
That's right.
and we'll do the roll call vote. Commissioner Wilson,
Aye.
Commissioner Moore, Commissioner Uribe.
I'm sorry, I have a question for legal counsel, because when we voted on this, the amendment that happened in the 2020 election would revert back to the decision made? Can I get a point of legal clarity on that? When the decision was made, because I thought we were going to do a consensus. There were three opportunities. So I'm trying to understand, are we inadvertently saying that vote was no good because of new information? Can you clarify?
No, you're just changing your position. I mean, there's no binding effect upon subsequent boards with respect to it. So you're just changing your position at this point in time.
But we're changing it based on, because
Based on
I'm
the
trying to
charter,
understand,
charter
how
amendment.
do we?
Based on the charter amendment.
The
And
charter
the
amendment.
charter
That's the
amendment-
new information.
allows us to basically
It's-
vote on it again.
It's not that the charter amendment allows you to do that. The charter amendment is a factual change in the circumstances. And so you're now voting in view of that change which has taken place.
And the change of the circumstances are,
Or that you now have a charter amendment with specific prohibitions and restrictions that relate to Split Oak. And even though that charter provision has an exception to that, you're basically saying that that exception is not applicable.
It's not.
I'm worried about the legal aspect on this, because Commissioner Bonilla, I respect that you wanted to bring this up, and I find merit in you bringing it up. I'm just worried, are we going down a dicey field? Like Commissioner Scott has no clue. We weren't briefed on this, because when I asked Byron about this, Byron said Commissioner Bonilla is going to present.
Okay.
I mean,
I think
So-
I've mentioned all those things already,
So,
Commissioner.
Yeah, I mean-
Commissioner Uribe, and but we talked about all of that probably while you were
yeah,
out.
I
but-
mean, so
If
you feel legally that we can do this?
Sure.
And
Now, there are consequences to everything you do.
what consequences are there
And,
on that?
you
I mean,
know,
that's the thing, we don't have any information
And
to,
I've mentioned that, but I'm not going to sit here and tell you that you can't do something when you can. The fact of the matter is, back in 2019, you agreed to support something. Now, a lot has transpired since that resolution was adopted by the board. I'm sure that there may be some reliance upon that resolution, and I'm sure there is an argument that could be made by other parties involved in this process, that they've relied upon that, and it may give rise to some consequences. I'm not here to, I can't tell you what all those consequences would be today, but that's a potential that exists. I can't prevent someone from
Perhaps, Jeff, what you can
filing
add, if the
litigation.
They
impetus
shouldn't have
is
relied.
December 5th, if that's the impetus, the board may want to consider, well, you're in the middle of voting, but if that's the impetus, we've already said we aren't going to be speaking at that meeting,
It doesn't-
which would then give the board more time to actually really understand what it is you're being asked to do today.
I understand, but Commissioner Wilson brought a point that that day, they're making a decision or relying on what our decision was.
now.
It's like I understand the urgency. Please understand that. What I'm confused on, and I think there's some validity to your points. What I'm confused on is, what are the implications of making this decision? Can this change anything? Is this actually happening? I mean, we have a lot, we don't know. And I feel like it's warranted. Trust me, I'm warranted for the conversation. What I'm worried about, like you said, consequences. Is that day a decision being made based on this right now? Is it a procedure they're doing? If I could
Okay.
just get.
We do
something-
have a motion and a second on the floor.
I'm
and-
not ready to vote on it. I mean, I think that's where I
Okay.
am. I don't, because I don't want to say no, because it doesn't mean I'm against, but I don't want
But
to say aye in the
It
sense
is
of
a
I don't
proper
know.
motion. You are going to have to vote.
It's difficult to vote on something that we don't
Okay.
have every accurate information.
All right. I
So-
think,
What I'm trying to accomplish is that we have staff going to the meeting on December 5th to support the voters.
Or at the very least, don't show up in opposition to them.
okay.
Well, they're not,
We-
well, the bare
Okay,
minimum.
we don't want to kind of go back over everything that we already
I know,
said to
but-
get to this point.
Okay, I mean, can
Commissioner?
we amend the motion? Because honestly, if they don't speak, is that an option? Byron says they
Okay.
weren't going to
All
speak.
right, so.
Does the
let me-
motioner and the second, do
So-
you want to entertain an amendment to the motion?
So
Okay.
what you probably missed was that all this time, staff has been directed to support the road. So if they're asked any questions at that meeting, they're going to have to speak in support of the road, because that's what they were directed by this board to do in
Okay.
2019.
Okay, Commissioner Uribe, you must vote.
No, I'm asking if she would consider amending your motion
To
for the
what?
consensus that was offered as part 3. Because you're asking us to make a decision without all the facts. But the consensus one, version 3, was pretty much in line without making us, quote unquote, switch the vote, but actually
Well, then
consensus of what.
that doesn't give staff any real direction.
Wait, you remember your part 3 consensus of, there's a consensus on the board?
Staff is not required to do anything by the board with a consensus. We have to give official vote action,
Okay.
board action, to require staff to do something.
And all we're asking on this.
That's contrary to what the direction the staff has been given before. Okay. So, in all due respect, Commissioner Uribe, it might be a difficult vote for you, but you need to vote unless they modify their
I want to
motion.
pass. I want to pass on to the next.
Okay, I don't
And
think.
my question definitely is,
you-
what are you afraid of? What are you?
What I'm concerned about is the legalities and the consequences of
Okay,
what we're doing
I
here.
don't-
And I don't want to not
I
support
don't
it.
think that you can abstain from the vote. You're present, you have to vote.
I wish you would consider amending it because I'm worried about that one thing. Are we rescinding, by doing this, are we actually saying we've sent the state this and this is what we want, and now we're saying, no, we don't, only if we're called upon or we're asking them to go in public comment and say they've changed their mind?
Okay,
That's where my concern is.
we understand that.
Do-
We
We're
still have a
supporting what the
motion and a
voters
second. We still have a motion and a second, Commissioner Uribe. You got to vote.
Okay, aye.
Okay. Commissioner Gomez-Cadera, Commissioner Bonilla,
Aye.
Commissioner Scott.
Mayor, I abstain, and I think I'm able.
Can't.
I thought that I am able to abstain if I have a conflict, given the fact these decisions were made 2 and 3, or 3 and 4 years prior to me.
Okay, I don't
No.
know that that's a
cannot
legitimate
abstain.
That's not a conflict.
conflict.
asking you to uphold the charter.
I vote aye.
All right. The motion passes. Okay. That, and I'll, for argument's sake, I'm going to vote aye. The motion passes. What we'll do at this point is staff has the direction, okay, that the board, given the change in time, no longer supports the application. Okay, and that's at the FCT meeting on December the 5th. If it comes up, that is what staff will say. Okay. All right. All right. With that, we have one other item.
Want to be clear, so that was just on the discussion for the 5th. That's not about the there was,
It was about
that motion
was
did
about
or did
the
not
5th.
include the resolution?
It was not a resolution because we can't craft that today. This is for the direction on the 5th.